Okay, I didn't know how many people were going to show up because I butchered the scheduling for this live stream. I do apologize. I'm going to give everybody some time to get in here. I'll give everybody a few minutes. I'll be right back. I completely and entirely forgot about this live stream. I forgot that I scheduled it because it's probably because I scheduled it so far ahead of time. I scheduled it like 4 days in advance. Usually I schedule all my live streams the night before. And I think that's what caused me to forget about it. But like I said, we'll give everybody a few moments. Can everybody hear me? If you can hear me, please say yes. And because I cannot see any chats right now. Oh, okay. I see. Okay, cool. Thank you for that, L Weeds. L Weeds. I don't know how to pronounce the rest of it. Okay, John. Thank you. And see what's on the screen, right? You can see what I'm sharing. It's not too small. Bear with me just a couple more minutes. I'll be right there. One more minute. Okay. Hey, what's up, Warren? Yeah, a lot of people that were here to watch the live stream last night. They're not here now because um, I missed it. And folks, everyone here that knows about me on my channel, you can attest to this. I've never missed a live stream. Never have I. Now, I may have been late many times, and I may have even rescheduled a couple of times, but I've never outright missed one. And you all know that. And Warren, I apologize. I never have done that ever. But the good news is I was happy. I was having fun. Oh, I was wondering where you were at, Valerie. Good evening, everybody. Valerie, Yvonne might show up here at some point. Yeah, you didn't miss. You didn't miss anything, Warren. I was the one that missed. Okay. On March 13th, 2026, I filed a defamation lawsuit against Earl David Warden impersonator / frauditor Eric Neal, aka the Skip Tracer. I also filed an application to proceed without paying court fees, including the filing fee, which was the filing fee was $400, I think. I claimed that I was indigent. All right. And if we look at the case docket right here, all right, this is Stout v. Neal. That's the case filed March 13th, 2026. Now, I filed my complaint, which is the first docket entry here. And then I filed my motion for leave to proceed in form of paupers. It means to proceed in the form of a pauper, which means proceed without paying court fees. Eric Neal then invited me in a series of YouTube community page posts and videos to serve him with the lawsuit in this case, or serve him with process. Neal claimed that he would not evade service of process, provided locations where he could be served, claimed that he would schedule a date and time to be served, and claimed that he was enthusiastic about litigating the case. And we're going to look at Neal's posts now. Can everyone see this? And folks, I'm going to take my time. Oh, here's the here it is. Oh, it's not. Oh, there we go. There we go. All right, now can everybody see it? This is one of the Skip Tracer's posts, one of his series of one of us in a series of posts. Here you see the Skip Tracer. This is his account at Frauditors Exposed. Dude, I'm begging you, please have me served. So he learned about my lawsuit. I can't remember how. I don't know if he learned it from my channel or if he discovered it through some third party or discovered it on his own. I don't know. Please have me served. Tell the process server to email me and name the time and place. Remember all this, all of what he's saying. Remember this. Because this is going to reflect on his character later. I mean, this will be a reflection of his character later. I will accept the paperwork with a smile. You know full, oh, I don't even have to talk about that stuff. My attorney is going to have a field day with you. Yeah, so folks, in the description, I provided a link to the previous video I made about Eric Neal. If anybody wants to, watch that video, and and hear about all this other stuff that he's talking about, go watch the video. I provided a link. My attorney is going to have a field day with you. Again, have your process server reach out to me. I will drive to him if necessary to get the paperwork. Or tell him to come by my office. Folks, he even said it. He said it himself. He's begging me to serve him. Tell him to come by my office. I'm here right now for another hour. Hey, oh yeah, hello everybody. Paul, what's up? Robert, Steve. Why won't it won't let me expand? There we go. Oh, now it lets me do it. But I'd rather do it in the Google Drive. But I can't find the plus and minus when I'm okay, screw it. Okay, can we all see this? This is his second post. Post from the skip tracer at Frauditors Exposed. I'm going to be in my office all day tomorrow. You said you're suing me, so let's get this show on the road and get me served. If this isn't somebody admitting that they will accept service of process, I don't know what is, folks. Without even going any further. I mean, do you need a little help with the money to pay for the process server? It should only be like $60. Another post by the skip tracer. Another ridiculous email by Mark Stout. Oh, wait, did I? Oh, yeah. And we'll get into the email later. Another ridiculous email by Mark Stout, the experienced pro se litigant. Oh, with that, never mind. Forget about all that. We'll talk about that later. Still waiting to be served is what he says, right? Still waiting to be served. Neal also claimed in a series of YouTube community page posts and videos that I committed perjury by claiming that I was indigent and applying to proceed without paying court fees. Neal claimed that I had been receiving income from YouTube, Upwork, and other sources. So let's look at Neal's posts. Now, we just reviewed all of Neal's posts admitting that he will accept service of process. Did we or did we not? Did his posts clearly, there were clear admissions by Neal that Neal would accept service of process? Were they or were they not? I need answers. Yes, right? If those posts weren't the clearest admissions that he would accept service of process voluntarily and enthusiastically, not just voluntarily, enthusiastically. Okay, because I want to establish that first. All right. Then Neal, then Neal made, oh, you know what? I missed a hold on a second. Okay, well, yeah, here's one. I exposed Mark Stout for likely committing perjury while showing full evidence. So he's accusing me of committing perjury because I claimed I was indigent. He's claiming that I was not indigent and that I lied. So hold on a second. Let me see which one this is. Why is it not? For some reason, I'm not able to show. Wow, this is weird. Let me refresh the page. Oh, I got it. I think I know what happened. There it is. Okay. Okay, I figured it out now. Okay. So here's my application to proceed without paying court fees. The skip tracer posted that application and then stated in the post, in 2021, Mark Stout claimed he had zero income. How can Mark have zero income and zero expenses for all these years? I mean, he wouldn't commit perjury, would he? And then he goes on to say in the post we reviewed before this, I committed perjury. He claims that I likely committed perjury while showing full evidence. He's claiming he has showed full evidence that I likely committed perjury. And everyone saw those posts, correct? Okay, and here he further states, he says, I signed a document with the court under penalty of perjury that I made no money in 2025 and had not $1 in his bank account. And then Neal says the crazy thing is I didn't put even close to what I know out there. And again, and that is a complete and entire fabrication. Neal knows absolutely nothing else. Okay. What he thinks he knows, he doesn't even know. So he certainly doesn't know anything else. All right. I then became ineligible to claim indigency in the case. All right. So let's go back to the docket. So look at this filing fee. All right. This is the money order. This is my money order that I sent to the court to pay the filing fee because I became ineligible for indigency after I filed the case. So what I did was I filed a motion to withdraw my motion for leave to proceed in form of pauper. So I'm asking the court to withdraw my motion to proceed without paying court fees because I can now afford to pay the fees. Okay. And there's the docket entry for that. And then the docket entry for the filing fee is docket entry 6. And I paid the filing fee, $405. The judge then granted my motion to withdraw my motion to proceed without paying fees. Okay. The court granted that motion. And then on May 28th, 2026, the court issued process to be served on Neal. So after the court granted my motion, they issued a summons to Eric Neal, commanding him to answer my lawsuit. They issued a summons, and here's a copy of the court's order granting my motion and issuing summons to Eric Neal. Oh, here I forgot about another post that Neal made. Here's what else he says. Thank you, Stout. More evidence for my attorney if you ever get me served. I've been waiting. Are you back to being broke after paying the filing fees and withdrawing your laughable indigency claim after I found your Upwork profile, which you took down? I love how you actually admitted to lying in your post. Can you hurry up and get me served properly? Time is running out. Oh yeah, and I forgot to show you this. So he said time is running out because I had 90 days to serve him from the date that I filed, which was March 13th. But guess what? I filed another motion for an extension of time to serve Neal. So I'm asking the court to give me an extra 30 days to serve Neal. Oh, yeah, I didn't put that in my script. Well, I'll come back to it later. So Neal, because Neal was being evasive, and I didn't know whether or not I would be able to serve Neal within the 90 days because of how evasive he was. So I asked the court for another 30 days to serve him, and the court granted my motion. Here's my motion for an extension of time to serve defendant. The judge on docket entry 12, electronic order granting motion for extension of time to serve defendant. So time does not run out until I say time is running out, Neal. I'll tell you when time is running out, stupid. Okay, you dumb. And I just proved that I will be the one telling you. I showed you the docket. I filed you said time is running out because you thought the 90-day deadline that I wouldn't be able to serve you before the 90-day deadline. But I don't have to serve you before the 90-day deadline, dumbass. I can just file another motion for an extension of time and have you served whenever I want. So keep your dumb, stupid mouth shut, Neal. Okay, you have no idea what you're talking about, and I just proved how stupid and dumb you are. Look how I made you look right now. You said time is running out. It's not running out until I tell you it is. Okay? Okay, now can everybody see this? On April 26, 2026, I mailed Neal a waiver of service of process. So a waiver of service of process is it's an admission by the defendant that they will accept service of process without having to be served by a process server. They're consenting to they're subjecting themselves to the litigation and consenting to service of process, right? So without having to be served formally. And according to federal law, the federal rules, that is a requirement. If I ask if a plaintiff asks a defendant to waive service of process, the defendant by law has to do it. They have to make it easier on the plaintiff to sue the defendant. That's an obligation the defendant has according to the law. The defendant is required to make this easy for the plaintiff. Okay, that's the purpose of the rule. And if you don't, if a defendant fails to sign the waiver and fails to waive service of process, the defendant must pay the plaintiff the costs of serving the defendant. So whatever it costs me to have Neal served by a process server, Neal will have to reimburse me that amount. On the same date, I emailed Neal a copy of the waiver. And here's the email. Dear Mr. Neal, remember, folks, remember all his posts and his videos. Oh, wait, did I ever show the oh no, that's later. That's later. Okay. Remember all of his community page posts, all of his admissions that he would consent, that he would accept service of process. Remember all that. So I emailed Neal. So I'm thinking if he's in such a hurry to be served, well, then he should have no problem waiving service of process. This will get him served even faster. He can just let me send him a copy by email. Here you go. So, dear Mr. Neal, regarding my lawsuit against you, you have repeatedly stated in your YouTube videos and on your YouTube community page that you will accept service of process, that you can't wait to litigate the case, and that you can't wait to hire an attorney to defeat me. Please find enclosed a waiver of service of process. If you do not waive service of process, you will be required by law to reimburse me any and all costs and attorney's fees paid by me to have you served. You have 30 days to return the completed waiver to me by email, but since you're so enthusiastic about proceeding with the litigation and exclaim that your attorney will promptly and swiftly resolve the matter in your favor, I can expect you to complete and return the waiver as soon as you receive it. Folks, am I being reasonable or unreasonable? Based on Neal's community page posts and his admissions that he will accept service of process, his enthusiastic admissions, is it not reasonable for me to believe that he would have no problem signing and returning this waiver of process immediately back by email? Is that not a reasonable expectation at this point? Very reasonable, Warren. Exactly. You are not to attempt to represent yourself in this matter or proceed pro se. You will hire an attorney who I will communicate with throughout the litigation. I only entertain and communicate with highly experienced and reputable attorneys. I do not entertain or take seriously naive, inexperienced, unknowledgeable, and illiterate pro se litigants like yourself. If you do attempt to proceed pro se, I will essentially be litigating this case without you like you did not even exist. You will be on your own. I will not guide you, teach you, or hold your hand throughout this matter. And I say that because I kind of did that with Long Island Audit when I sued him, you know, in those lawsuits, in those cases. I kind of helped him some of the way. Of course, to make it easier for me to litigate against him. It was obviously for reasons favorable to me, not him, but I still did it. And I'm telling you, you won't enjoy that same benefit that I sometimes gave to Long Island Audit. Because you already have a copy of the complaint and are more than familiar with the case, I had not attached one, but I actually went back, and I sent him an email right after this with a copy of the complaint. Anyways, I did send that to him, but it's not important for purposes of this discussion. Neal then admitted in a series of posts and videos that he was refusing to waive service of process. Okay, and here's Neal's post discussing my email. Here he is. He posts the email that we just reviewed and that I sent to Neal. Okay, he posts that to his channel and states, I just got an email. Remember, he's required by law to make it easier for me to serve him with this lawsuit. He's required by law to accept the lawsuit from me. He's required to accept the lawsuit from me. Or pay my costs of service of process. Okay, it's that simple. Here's what the skip tracer says. I just got an email that I think takes the cake for most ridiculous thing I've received in a while. Mark Stout, who has been lying about me publicly, is now emailing me, telling me what I will and will not do in a legal matter, ordering me not to represent myself, and threatening me with process server fees if I don't make things easier for him. Let me be clear, I'm not evading anything, but I'm also not here to make Stout's life easier for him, especially not after his BS lies. So he's openly admitting that he's refusing to comply with the federal rules and federal laws requiring him to make it easier for me. He's openly admitting that he's refusing to comply with the law and with federal rules of civil procedure. And he's admitting that he's refusing to comply because of my, quote, BS lies, end quote. So he's even providing a reason for refusing to comply. He's justifying it. He's saying it's okay because of this factor. And folks, personal opinions and are not legal arguments. Your personal opinion, Neal, is not a legal argument. Just because your opinion is that you don't have to comply because of BS lies, that's not a legal argument, Neal. That's not going to hold up in court. You understand that, right? And as for the threat about paying his process server fees, yeah, good luck with that. The likelihood of a judge enforcing that, enforcing the law, enforcing the federal rules of civil procedure, I believe it's Rule 4. Under these circumstances, the likelihood of a judge enforcing that under these circumstances is pretty close to zero, especially given the context here. This is an open and clear admission that he is refusing to waive service of process. He's openly admitting that he's refusing to make it easier for me to sue him, refusing to make it easier for me to serve him, refusing to make it easier for me and not a process server to serve him the lawsuit. And again, he posts the email that I sent him, instructing him to waive service of process or inviting him to waive service of process. And here's another post from the skip tracer. Attention, moron. I told you that I'm not going to evade service of process, especially since I know professionally a decent amount of process servers in my area. But I'm not here to make your life easier. Again, he's openly admitting that he's refusing to comply with federal laws and federal rules requiring him to make this easier for me. He's openly admitting it. And here, folks, is a video. Listen to what he says. You don't really need to see it. Listen to what he says. Tell me if you can hear it. Oh, hold on. Let me put my headphones on.
Mark Stout recently filed a lawsuit against me in the United States District.
Can everyone hear the video? We only need to hear like the first 10 seconds of it. Did everyone hear it? Okay, so everyone listen up. This is what Neal is stating in his video. And again, he's screen sharing my application to proceed without paying court fees. And these are his statements.
Mark Stout recently filed a lawsuit against me in the United States District Court of Massachusetts. Now, I am still waiting to be served on this. He wants me to do a waiver of service, which I'm not going to do, but if he sends out a process server, I will not evade.
He said he just openly admitted that he's refusing to waive service of process. Let's listen to that again. He openly admitted it. He said he will accept service of process from a process server, but he's not going to waive service of process.
Mark Stout recently filed a lawsuit against me in the United States District Court of Massachusetts. Now, I am still waiting to be served on this. He wants me to do a waiver of service, which I'm not going to do, but if he sends out a process server, I will not evade.
Okay, so everyone heard that he's requiring me to send out a process server. He's openly refusing to waive service of process as required by federal law. Okay, now he posted He screenshotted one of my YouTube community page posts, posted that to his community page, and stated, I figured out what Merb was talking about that he didn't want to say that would make the service costs rule defective. I am also not going to say, and Stout is probably too dumb to figure it out. Well, we just proved that Neal's the one that's too dumb to figure any of this out. We just proved that in this video already. Okay. So that's just Neal projecting. We just proved he's the one that's too dumb to figure any of this out. And here's what Neal's argument is. He's saying not that his failure to waive service of process was defective. His decision was defective. He's saying the rule itself is defective. He's saying the service costs rule, which he doesn't even, it's rule 4 of the federal rules of civil procedure. He's saying now that the law is defective. Classic frauditor argument, folks. Classic frauditor argument. These are the lies that they tell themselves. He's now trying to convince himself that rule 4 is defective. Not that his failure to comply with the rule is defective. He's the one that's defective, not the law or the rule. But isn't that a classic frauditor defense? Neal, look how dumb and stupid I made you look just now for thinking that a judge is going to rule that the law is somehow wrong, but you're right. Do you know how deluded you sound? You really think a judge is going to rule that rule 4 is defective and not that you failed to waive service of process and that you failed to comply with rule 4? Do you really believe that? You are deluded. That is what makes this so easy for me. This is why suing frauditors is so easy, because they're just so dumb and stupid. They do all the work for me. Concerning Stout's lawsuit against me. Wait. Let me go here first. Okay. So we just reviewed and discussed all of Neal's open admissions that he was refusing to waive service of process and refusing to comply with federal laws and rules requiring him to waive service of process. Okay. Because he failed to waive at this point, I have to serve him. Traditionally or formally now, because he's refusing to comply with the law. So now I have to take matters into my own hands and pay to have him served. So I then paid the Essex County, Massachusetts Sheriff's Office $100 to serve Neal with my lawsuit. Now, remember, Neal pretended in all of his posts that he wasn't scared of my lawsuit or scared to litigate against me. Neal repeatedly invited and encouraged me to have him served. So I called Neal's bluff. When the sheriff's office emailed Neal to schedule a time and place to serve Neal, Neal failed to respond. When the sheriff's office texted Neal, Neal failed to respond. When the sheriff's office called Neal, Neal failed to answer his phone or return the voicemail. Remember all those statements by Neal? Have the process server reach out to me by phone, text, or email. We can schedule a time and place to meet up for service. Remember all those statements? When the sheriff's office finally knocked on Neal's front door to serve him, Neal refused to answer the door and went into hiding. After all of Neal's fake tough guy rhetoric and fake tough guy statements in his posts, I proved that Neal is just as soft weak, scared, and harmless as any other frauditor. The sheriff's office left the lawsuit at Neal's door and mailed him a copy, thereby serving Neal. Neal later retrieved the lawsuit from his door and claimed in a post that I could not hire the sheriff's office to serve him, but was required to hire a private process server instead. And that is this post. Here's what he says. Here's some non-attorney advice for whatever dumbass is out there. So that's you, Neal. You're talking to yourself. So here's your non-attorney advice for you because you're the dumbass here. We just proved it. Oh yeah, okay. Here's what he says. Don't hire, number 5. Don't hire a sheriff to serve federal lawsuit papers. Folks, a sheriff absolutely can serve federal lawsuit papers. That's not even something that's even disputed in court. The only person that would make that claim is a frauditor. That is it. Again, this is his warped, diluted understanding of the law. And these are frauditors, again, classic lies they tell themselves. Okay. Don't hire a sheriff to serve federal lawsuit papers, especially don't do it when someone like me has quality surveillance cameras on their property. Yeah, to prove that you were served, stupid. Thank you for telling me that you have video footage that I can now subpoena that. Thank you. Or you're going to provide that to me. That's what you're going to do. You're going to give me those videos or you're going to get sanctioned, Neal. Okay. Thank you for this post because I missed that the first time. Now I know to get those videos from you. And folks, we all know from my lawsuit against Long Island Audit that if he refuses to give me those videos, he is going to suffer the consequences, isn't he? Isn't he, folks? If he doesn't give me those, we saw what happened when Reyes and Zinman refused to give me their videos and destroyed the videos. After the court ordered them to give me the videos, what did they do? They got sanctioned. The court sanctioned both of them. That's what's going to happen to you, Neal. I want those videos. You're not going to give them to me. The court is going to sanction you. You understand that, right? But hold on, folks. Let me get something to drink real quick. Let me expand this. Oh, actually, I don't need to do that. On July 7th, 2026, Neal got scared and hired an attorney. I previously instructed Neal in an email that he was not to attempt to represent himself in this case. Remember that email we reviewed and discussed earlier? But he was to hire an attorney because he did not know the law or know how to make sense out of the law for himself. Neal realized how dumb and stupid I made him look, so he did exactly as I commanded him to. Didn't he? Didn't Neal do exactly as I commanded him to, folks? I told him, don't you dare try to attempt to represent yourself. And he got scared and listened. Neal's lawyer, Eric Hagan, then emailed me to confer about Hagan's motion to dismiss and motion to strike. And this is the email thread on the screen. This is the email from Eric's lawyer. Eric's lawyer is also named Eric, but spelled with a K. So he reached out to me to confer and notify me that he was going to be filing a motion to dismiss and a motion to strike. Okay. So I emailed him back. I responded with an amended complaint. I then amended my complaint to include another count of defamation. So I'm already suing Neal, and we're going to review the complaint here right now. I already sued him for defamation. All right. I already sued him for multiple counts of defamation. I then amended my complaint to include another count of defamation arising out of Neal's statements that I committed perjury. Remember, he said I lied when I stated I didn't have any sources of income. Okay. And here's the complaint. We're going to review the lawsuit now. I want to make sure I don't get the addresses in here. Okay. I guess we'll just skip the introduction part and go straight to the facts. Okay. All right. Can everyone see the text on the screen? This is the lawsuit against Neal. I can't show you all of it because some of it contains personal addresses and information, and I don't want Neal to file a privacy complaint, a privacy claim. So Neal's lawyer stated he was going to file a motion to dismiss. So I responded by adding another count of defamation to the lawsuit. And here's the lawsuit. Facts. Plaintiff's YouTube channel. Plaintiff is a YouTuber. That's me. I'm the plaintiff. Plaintiff's YouTube channel is Frauditors Exposed. Plaintiff's channel features videos about Earl David Warden impersonators or First Amendment for auditors or frauditors. Earl David Warden conceived First Amendment auditing in the early 2000s. Warden is a serial rapist and registered sex offender and raging narcissist and misogynist. In the 1980s, Warden impersonated law enforcement, stopped unsuspecting female victims in their vehicles, and raped them in their back seats. The details are brutally graphic. One of Warden's victims identified Warden in a photo lineup, leading to Warden's 1980s rape conviction and sex offender registration. In the 1990s, Warden was again charged with raping another woman, but the charge was reduced and Warden was freed. Warden was recently convicted of molesting his daughters in the early 2000s and is now serving a 20-year prison sentence for those convictions. In the early 2000s, before YouTube and smartphones, Warden sought out female administrative employees working in government buildings and filmed his encounters with them in known and purposeful violation of building safety and privacy policies prohibiting filming. Warden sought out women working in government buildings because he knew where the women would be and at what time, that they couldn't just leave his presence, and that he could obtain their contact information, often listed on business cards displayed in the government offices. Warden knew that his filming made the women uncomfortable. During Warden's encounters with the women, Warden would attempt to groom the women with superficial charm and a false image, and would attempt to reassure them that he would never hurt them, and would suggest to the women that they weren't uncomfortable, just shy. Warden would become furious when the women rejected his grooming attempts. When the women asked Warden to stop filming or to leave, Warden refused. When the women attempted to leave Warden's presence, Warden would follow the women around the building. When the women called the police and the police removed and trespassed Warden, Warden became even more furious. Warden would then publish his videos to his website. Warden's video titles and descriptions defamed and insulted the women. Warden's video descriptions included the women's names, addresses, phone numbers, and emails. Warden's statements in his videos and Warden's video titles and descriptions encouraged viewers to contact, harass, and threaten the women. Warden attracted hundreds of thousands of registered, convicted, or accused sex offenders and ragers to his website, where he cultivated a loyal following of like minds. After Warden began receiving an overwhelming amount of online criticism and negative publicity from the media about Warden's trespassing, disorderly conduct, harassment, stalking, and defamation videos, Warden conceived a euphemism for his illegal activities: First Amendment auditing. Warden characterized his illegal activities as auditing because that word sounds better than trespassing or disorderly conduct or harassment or stalking, etc. Warden incorporated the First Amendment into his euphemism because the First Amendment states that Congress shall make no law abridging the freedom of speech or of the press. And Warden claimed that if he was filming his illegal activities were no longer crimes, but became free press. In response to Warden's euphemism, the general public began calling Warden a frauditor and characterized his illegal activities as frauditing. After smartphones were introduced, Warden's admirers began imitating and copying Warden, creating their own YouTube channels and becoming Earl David Warden impersonators. Frauditors have since expanded their target victims to include anyone and everyone. Folks, does everyone here enjoy my characterization of frauditors? Enjoy my characterization of the narrative? Does everyone here enjoy my narrative? This is the narrative. This is the narrative, the argument and narrative that's winning in court against frauditors, against Long Island Audit, against Eric Neal, against any of them. Thank you, Paul. Thank you. This is the truth. So Warden's admirers began imitating and copying Warden after smartphones were introduced and everybody had a smartphone. Well, now anybody can be an Earl David Warden. So that's what happened. His followers began imitating and copying him, creating their own YouTube channels like Long Island Audit, the Skip Tracer, all the frauditors, and becoming Earl David Warden impersonators. Frauditors have since expanded their target victims to include anyone and everyone. Plaintiff exposes plaintiff is me. I expose Earl David Warden impersonators or frauditors on my YouTube channel. Frauditors are compulsive and pathological liars and frauds. Plaintiff exposes frauditors' sex offenses, past criminal convictions, frauditing convictions, frivolous legal theories, dismissed lawsuits, and other personal secrets frauditors desperately attempt to keep from the public. Plaintiff is the nation's leading expert on frauditors. Yes, I am America's leading expert on frauditors, if not the world's leading expert. Plaintiff was invited by the Dr. Phil show. Remember folks, remember that I showed you the emails from the Dr. Phil, from the media, his media team. I remember I posted that. I was invited by the Dr. Phil show, by Dr. Phil himself, to appear on the show as an expert on frauditors. Plaintiff also appeared in a documentary as an expert on frauditors. Plaintiff has appeared on countless YouTube channels as an expert on frauditors. Plaintiff submits amicus curiae briefs in support of defendants to frauditors' federal lawsuits. So what I'm doing is I'm clearly establishing with the court that I am the authority on frauditors, and what I say about them is the truth, not what Neal or any of the frauditors say, because they're not the experts. They're the compulsive and pathological liars. So I'm clearly establishing with the court that I'm the expert here on them. Okay. And I'm demonstrating why I am. I'm proving why I am. I'm establishing with the court that I have the authority and that what I say about frauditors is true, not what any frauditor says about themselves. And then I go on to talk about I guess when remember my memo against Reyes and all that, yada yada. Many of plaintiffs' viewers are professionals, including lawyers, court staff, and judges. Many of my supporters, subscribers, people who have sent me money, emails, comments, many of you are legal professionals. Many of you are lawyers. Many of you are attorneys, court staff, and there was 2 judges that follow my channel. One of them is a judge in Alaska. Okay, I'm not going to get into details with that, but yeah. Prosecutors watch my channel. Law enforcement watches my channel. Frauditors watch my channel to learn about themselves in secret. They have to secretly learn about themselves here. Okay. And here, defendant's YouTube channel. And folks, what we're doing is we're reviewing my lawsuit against Eric Neal, my defamation lawsuit. Defendant's YouTube channel, or the Skip Tracer's YouTube channel. Defendant is an Earl David Warden impersonator or frauditor. Defendant's channel is the Skip Tracer. Defendant's channel features videos of defendant frauditing, videos of defendant discussing frauditors favorably. Oh, you know what? I think this might be this is not the amended complaint. I need to get the amended complaint. Hold on. I need to get the amended complaint. Remember, I amended it to include that claim for perjury. Okay, let me get it. Okay. I got the amended complaint. Okay. And we'll just pick up where we left off. I mean, they both essentially kind of say the same thing. Okay. Defendant's YouTube channel. Defendant is an Earl David Warden impersonator or frauder. His channel is a Skip Tracer. Features videos of him frauding, videos of him admiring, promote. Oh, yeah. Defendant's channel features videos of defendant frauding and videos of defendant admiring, promoting, and defending frauditors. All right. Defendant's defamatory video. All right. This is the video that I'm suing Neal over. All right. That I'm claiming that all of his defamatory statements arise out of this video. Well, we don't even need to get through all of that. Let me see something here. We already know the situation with that. Okay, let's start right here. On October 9th, 2024, Douglas Kalagian, a documentarian, published to his YouTube channel a video titled "I Audited First Amendment Auditors." And I believe everyone here saw that video. I provided a link to it on my channel at some point in a community page post I'm pretty sure everyone here is familiar with that. Douglas Kalagian, his channel is I think it's called Douglas Kalagian. Yeah, his channel is his name. His name is his channel. So go check out his video if you haven't seen it. It's called "I Audited First Amendment Auditors," and I appeared in the video as an expert on frauditors. Kalagian's video is about the frauditing movement. A frauditor, Nasty Nathaniel, appears in the video to defend frauditors. Plaintiff, me, appears in the video to expose and criticize frauditors. Nasty Nathaniel is a warden loyalist. Defendant's YouTube channel features video of defendant and Nasty Nathaniel frauditing together. Defendant and Nasty Nathaniel are close friends and allies. At 27 minutes and 20 seconds into Kalagian's video, plaintiff states to Kalagian, this is me having a discussion in the documentary with Kalagian about frauditors. Okay, and this is what I said to Kalagian. Most people don't find harassing people and stalking people entertaining. There are character deficiencies. These frauditors, there are deep character deficiencies, and they are in deep denial. Kalagian then responds to me, what do you think attracts them, and by them he means sex offenders, to this kind of work? Because on the outside, if you were just to hear First Amendment auditor, you're like, oh, this is somebody who is seeking to protect the First Amendment. I replied to Kalagian, why do they, again, sex offenders, flock there to frauditing? I think about this day in and day out. I've come to this conclusion. I think that those are people that are looking for something to kind of overshadow who they are, something that they can find a common identity in that is bigger than who they are, so that nobody ever has to really look at them. Okay? So that's what I stated in Kalagian's documentary. Can everybody see the text on the screen? So, in response, and here's where we review and discuss Eric Neal's defamatory video and his defamatory statements. In response to my appearance in Douglas's documentary, and in response to my criticisms in that documentary, Eric Neal on October 10th, 2024, published to his YouTube channel a video titled Frauditors Exposed Mark Stout's Glass House. Now, before this, folks, I didn't know who Eric Neal was. I never discussed him on my channel. I never heard of him. He knew of me. I did not know of him. Okay? He did not like that I exposed frauditors in that documentary. He did not like that. He saw the documentary. He heard my criticisms. It probably didn't help that I appeared in the video with one of his best friends, Nasty Nathaniel. So it probably didn't help that I not only made frauditors look dumb and stupid, but I made his personal friend and close friend look dumb and stupid in the same video. That probably didn't help. But before that, I didn't know about Eric Neal. There was no contact with him or communication with him. And he didn't like that I appeared in the documentary and exposed frauditors. He didn't like that I embarrassed and humiliated his friend and him. So he made a video in response, Frauditors Exposed Mark Stout's Glass House. So this is my first time hearing about this guy. When I discovered this video, because he tagged me in the video. So I open my YouTube, I see I was tagged, I go and I see this video. And then I discover his channel. Okay. In the video, defendant shows and discusses plaintiff's criminal history in Prince William County, Virginia. At the beginning of the video, defendant states, and here he admits it. He admits that he saw the documentary and he is visibly angry. He's visibly angry. Recently, I was watching this video. This was a premiere done on October 9th, 2024. I audited First Amendment auditors by Douglas Kalagian. At 50 seconds into defendant's video, defendant states, there's a lot of people that called out the auditors. Now, one of these individuals is a guy by the name of Mark Stout, and I guess he used to be an auditor himself, and then he turned to the other side of the coin, calling out the auditors or frauditors, as they say. I want to take a look at this guy because he was making some claims that a lot of the auditors were all criminals. End quote. He was calling them criminals, quote, he was calling them criminals. And this is what Neal is stating about me in Neal's video about me. His video in response to my appearance in the documentary. He was calling them criminals He's saying I was calling frauditors criminals, and from what I hear, he used to be one. He's saying I used to be a frauditor. I don't know if someone said, I don't know the truth to it. I didn't see these things, but he used to be someone that was a fairly aggressive auditor himself. There are a total of 7 viewer comments posted to the defendant's video. Okay, and here is where the defamation begins, folks. All right, his statements in response to your, and some of these folks might even be in some of these comments. Some of the people, some of these usernames and accounts may even be here in the chat right now watching my live. There are a total of 7 viewer comments posted to the defendant's video. Of course, all of the comments were in favor of me, were in support of me. And so thank you. So all of you, all of my supporters and all of my subscribers that had my back and that defended me, well, this is how I'm going to repay you. I'm going to sue him and prove how much what you say matters and how much what you say counts. I'm going to sue him. Okay? Because the first comment from RoboMax, a longtime supporter of Plaintiff's YouTube channel, a longtime supporter of me, states, most good people don't care when someone turned their life around after making bad decisions in their younger days. We care that they are honestly and sincerely working to make themselves a better person and positively contributing to society that they harmed in the past. That's what I've seen from Mark Stout, in the past few years. He's saying he's seen positive contribution to society from me. Frauditors, on the other hand, double down on those bad decisions of their past, continuing to harm those around them with no regard for anyone but themselves. And what does defendant replies to Rob Max? Quote, well, the bad decisions are still ongoing, so I don't know how much of his life, I don't know how much turning of his life around he has done, end quote. So when he's saying, well, the bad decisions are ongoing, he's saying that the crimes are ongoing. Because remember, what was Rob talking about? He's saying bad. We're talking bad. The video Eric made was about my criminal history. Okay, so when we're talking about the bad decisions I've made, we're talking about the crimes that from my past. All right. So when Rob says frauder, that I'm a better person and positively contributing to society. That's what I've seen from Mark in the past few years. Frauditors, on the other hand, double down on those bad decisions of their past, crimes of their past. Remember, the video that Neal made about me is about my crimes, my past crimes. So bad decisions of their past is crimes of their past. All right. Now Rob is saying frauditors double down on those bad decisions, which means they continue to commit the crimes. Neal is saying, well, the bad decisions or crimes are still ongoing. So I don't know how much turning of his life around he's done. So Neal is saying that I'm still committing crimes, that the crimes are still ongoing, when that is a complete and entire fabrication. I haven't been convicted of anything in almost 20 years. In almost 20 years. It's been almost 20 years since I've been convicted of anything. So the crimes are not still ongoing. That is a complete and entire fabrication, folks. And everyone here knows it, because I have openly and exhaustively discussed my criminal history on this channel. Have I not? We all know about my past. Everyone knows how long ago my past was and what my past was. The second comment from LHDG1, I believe that's Henny Dip, I forgot, but she's also a longtime supporter of my channel. She also commented to Neal's video about me. The second comment from Henny Dip, a longtime supporter of my YouTube channel, states in response to no quote, "This isn't nothing new. We already know this. We know this already. He, plaintiff, Mark Stout, me, really knows his shit. He also said he was very bad and he did a lot of effed up shit, but he's older now and he regrets all that shit people do. He regrets all that shit. People do have the right to change for the better," end quote. So there's Henny Dip defending me. The third comment from Judy LaPointe, another longtime supporter, follower, a longtime supporter of plaintiff's YouTube channel, states, quote, she's stating to Neal, "Check out anyone who is against frauditors and they all say the same thing about the auditors. It sure seems like they are correct. Seems like Mark has reformed himself and he admits to his past crimes." Remember what she says here, past, not ongoing, not ongoing. So even my followers and supporters know that the crimes are in my past and that they're not ongoing. Mark is as smart as they come, end quote. So what does Eric Neal reply to Judy? He hadn't admitted to everything by far. And we all know, folks, that is a complete and entire fabrication. I have admitted to every single crime in my criminal history, everything. What Neal is now doing is imputing to me crimes outside of the crimes in my criminal history. He's now saying I have further criminal history that I'm not telling anybody about or that nobody knows about. He's saying that I have some secret criminal history that I have not admitted to, when everyone here knows I have admitted to everything. He is now stating that there is more than what I admitted to, stating that I have more of a criminal past than what I admitted to. That's what he's stating. He's stating that I have more of a criminal past than the criminal past I have. That he's saying that I have more of a criminal past than the criminal past I have. There it is. So he's saying that I have secret criminal convictions that nobody knows about and that I haven't admitted to. That is a complete and entire fabrication. The fourth comment from Warren, and Warren, this is you. Warren is actually in the chat. How are you, Warren? Exactly, Warren, exactly. He never listed any of these crimes that he's claiming I didn't admit to. Well, if I didn't admit to them and they're a secret, then what are they? Go ahead and expose me. He never provided anything, any proof or any evidence. Never. Just bare defamatory statements. And this is from Warren, a longtime supporter of my YouTube channel, stated to Neal, "I'm a big supporter of Mark Stout, and he admitted he had a criminal past." And now what Neal is saying is that my criminal past, all of my criminal past and past criminal history isn't everything. That's what he's saying. He's saying that's not everything, when it is. Those are official court records and documents. Defendant replies to Warren, at Warren, he didn't admit to all of it. So there he is again defaming me. Again, he didn't list, he's saying I didn't admit to all of it. Okay, what did I not admit to then? Why won't you provide that, Neal? Because you're a liar. You're a compulsive and pathological liar. The fifth comment from CB states, quote, "Yeah, one of the things I hate about these issues is the premise that a person has to be clean to be worth listening to. Everyone has fallen short. Everyone does something others are going to not like," end quote. The sixth comment from Ken, a longtime supporter of my YouTube channel, states, quote, "He, Mark Stout, me, plaintiff, acknowledges his past. And now he exposes these lying POS frauditors for what they are," end quote. And what does defendant Eric Neal reply? He replies to Ken, Quote, from what I've seen, he has acknowledged very, very little of it. This was just one county, and there is a hell of a lot more I found, end quote. Folks, that is a complete and entire fabrication. I didn't acknowledge very, very little of it. I acknowledged all of it. And there wasn't a hell of a lot more he found. It was just one county. He's saying there was more than one county. That is a lie. It was just one. Prince William County is the only county I've ever been convicted in. He's claiming that there's more than one county and that there's a hell of a lot more convictions that he found. That is a complete and entire fabrication, folks. Again, he failed to list the convictions. He failed to provide any proof or any evidence because it does not exist. He is a compulsive and pathological liar. That is defamation. You cannot falsely claim that I committed crimes that I did not commit, or that I was convicted of crimes that I was not convicted of. You cannot do that. That is defamation. Ken responds to the defendant, further responding to him. He corrects the skip tracer. He's basically saying, no, he has been pretty upfront about his criminal past. He's saying, no, skip tracer, you're wrong. There is just one county, and there is not a hell of a lot more you found, because he's been upfront about his past on his channel. See, nobody even believes that Eric Neal. And this is why he has to keep lying, because he's desperate to convince somebody. And every time his lies fail, they get more and more desperate. And so that's what he's having to do. The defamatory statements are becoming more desperate because they're failing to achieve their desired effect, right? Which is to convince people to disassociate with me, or convince people to lower their esteem of me, or right? So, and then the seventh comment, we don't even have to acknowledge. Oh yeah, the seventh comment from Half Human, Half Zombie. He states, quote, he, plaintiff, which is me, Mark Stout, never was a genuine auditor. He actually admitted that he did harass public officials, which is a complete and entire fabrication. I never admitted that because I never did that. Unlike the claim, and this is not one of my supporters, folks. This is one of Eric Neal's supporters. And this is an Earl David Warden. Half Human, Half Zombie is an Earl David Warden loyalist. He has been leaving comments on that guy's channel in support of Warden since Warden's channel, since the creation of it. Okay, and Half Human, Half Zombie states, commented on Eric Neal's video, and Eric Neal replied to Half Human, quote, after I did this video, I found so much more, like a 2022 domestic in a different county. That is a complete and entire fabrication. He never found any domestic conviction in another county. I've never been convicted of a domestic, ever. Now, everyone here is familiar with, we can review it. We can review it, the lawsuit. So check this out. Let's go back up top. Okay, so we all remember what happened when I was falsely accused of domestic violence some years back, right? We remember that, right? Here's what happened, and I'll listen. I will repeat it as many times. As many times as necessary. I have no problem making myself look good over and over. Okay. Shortly after I created my YouTube channel, plaintiff's son's mother, who plaintiff had not seen in years, let alone lived with, falsely and maliciously reported to the police that plaintiff battered her on some sidewalk somewhere. Plaintiff was charged with domestic battery. Plaintiff's alibi, my alibi, was a nightclub surveillance video of plaintiff and plaintiff's lawyer friends partying in the nightclub at the time of the alleged battery in counties away from where the alleged battery occurred. So, folks, I had video evidence. I was on video at another location, miles away, at another time, at the time that this battery allegedly occurred. I have video of me editing miles away at a completely and entirely different location with witnesses. I'm partying with witnesses who know that I was there with them and I was not miles away at some other location battering my son's mother. Okay, so I had video evidence. I had an alibi proving that never happened. Okay, on the date and time that she said that happened, I was not even anywhere even remotely anywhere near the area near her. Okay, and I proved it. Plaintiff's alibi was a nightclub surveillance video of me and my friends partying in the nightclub at the time of the alleged battery in counties away, miles away from where the alleged battery occurred. The prosecutor attempted to confront the victim with my alibi. So the prosecutor attempted to call the victim and say, hey, I just saw this video of him in a nightclub, and you're saying he hit you on the sidewalk. He was on the sidewalk somewhere hitting you, but he was on a nightclub. He's at a nightclub somewhere else with his friends partying. Can you explain that? And they were trying to get her to explain how that could happen. So the prosecutor attempted to confront the victim, but the victim evaded the prosecutor and failed to appear at my trial. So the victim failed to appear at the trial because they knew they had been caught. The court dismissed my domestic battery charge. The victim later admitted to someone claiming to be a private investigator that she fabricated the allegations and admitted to why. So the victim herself, and I have this proof. She even later admitted to a private investigator that she made it all up, that she falsely accused me of domestic battery. She admitted that she made it up, and she admitted why she made it up. Okay. But I don't want anything to happen to her. I don't want her to get in any trouble. That's not why I'm discussing this. Okay. I'm discussing this to expose Neal. Okay. Plaintiff then revealed on his YouTube channel the domestic battery charge, the outcome of the charge, and the victim's admission, where defendant then discovered the information. So after all of that happened, I posted it all to my channel, and then Eric Neal discovered all of this on my channel. He discovered that I was falsely and maliciously accused. He discovered that I had an alibi. He discovered that the victim admitted that they made it all up, that they lied and made it all up. Okay, so Neal discovered all of that, right? But down here, Neal knew that I was innocent. Neal knew that I was never convicted of any domestic battery. Neal knew that I was exonerated and that I was falsely and maliciously accused. He knew that. But what does he say anyway? He says, I found so much more. After I did this video, I found so much more, like a 2022 domestic in a different county. That is a complete and entire fabrication. He knew I had he knew I didn't have any domestic convictions, and he knew the domestic allegation was false and malicious. And he still stated that I had a 2022 domestic, and he knew that I didn't. Not only did he know I wasn't convicted, he knew I was innocent and he knew I was innocent. So defendant's video contains 5 defamatory statements made by defendant about plaintiff. And then defendant's 6th defamatory statement. On April 28th, 2026, defendant posted an image of plaintiff's informal pauperous application to defendant's YouTube community page and stated in the post, quote, I exposed Mark Stout for likely committing perjury while showing full evidence, end quote. Defendant stated in another YouTube community page post, how can Mark have zero income and zero expenses for all these years? I mean, he wouldn't commit perjury, would he? End quote. So he's accusing me of perjury. He's claiming that I lied when I stated that I didn't have any income and that I was indigent. And his statements are complete and entire fabrications. They are defamatory, and I am going to prove that I didn't have any, that I was indigent. when I filed for that application. I'm going to prove that I was, and I'm going to prove that Neal defamed me. Okay. Now, here's where things get interesting. Is everybody still with me? Because here's where things get exciting. Can everyone see this? Can everyone see? I need everybody that tuned out, I need you to tune in, because this is where the video actually starts. This is where the video actually starts, folks. Okay. I then researched Neal's lawyer. Okay. After Neal's lawyer emailed me to confer about his motions, and after I served Neal's lawyer with my amended complaint, I then researched Neal's lawyer. Not only is Neal an Earl David Warden impersonator / frauditor, and we all know the reputations frauditors have, but I exposed Neal in a previous live stream. Neal attempts to justify CSAM and defend sex offenders in secret phone recordings and blog posts that Neal has desperately attempted to keep secret from his viewers. And we all know frauditors have reputations as registered, convicted, or accused sex offenders. We all know that. I also exposed that Neal's father is a registered sex offender. I researched some of Hagen's previous cases. So Eric Neal's lawyer's name is Eric Hagen. Both their names are Hagen. One is spelled with Eric's lawyer's name is spelled with a K. So I researched Eric Hagen's, Neal's lawyer, previous cases. In the let me show. I've got the wrong screen up. I then researched some of Eric Hagen's previous cases, some of Neal's lawyer's previous cases. And the very first case I found, folks, if this isn't telling, I don't know what is. If this is not telling, I don't know what is. The very first case I found was a lawsuit against the Department of Children and Families filed by Hagen on behalf of you guessed it, a sex offender father who molested his 9-year-old daughter and who filed a lawsuit because he got exposed. Okay. And this is that lawsuit. And here's Eric Neal's lawyer, Eric Hagen, Esquire for plaintiff. The plaintiff is Benjamin S. All right. And here's what happened. After the Department of Children and Families received reports that the plaintiff had sexually abused his daughter, it found those allegations supported based on a sexual abuse intervention network interview of the daughter. DCF therefore placed the plaintiff's name in its registry of alleged perpetrators. Okay, so Benjamin S. was then registered as an alleged perpetrator in some type of database or system because of the reports that he sexually abused his daughter. The plaintiff requested and was provided a fair hearing before a DCF hearing officer to contest the agency's actions. The hearing officer upheld DCF's actions in a thoughtful and comprehensive written decision. After the plaintiff appealed the hearing officer's decision, a superior court judge affirmed that decision on cross motions for judgment on the pleadings. On the plaintiff's appeal from that judgment, we affirm. The hearing officer's decision was based on allegations made by the plaintiff's daughter that, as summarized by the hearing officer, the plaintiff on at least 2 occasions entered her bed and pressed or rubbed his body against hers to the point of ejaculation. The daughter was 9 as of the date the allegations were first reported and as of the date of the hearing. The incidents allegedly took place close in time to her 9th birthday. She did not testify at the hearing, but her statements were admitted without objection through documentary evidence. The DCF investigator who attended the SAIN interview also testified at the hearing. The only argument properly presented by this appeal is the plaintiff's claim that the daughter's hearsay statements did not present sufficient indicia of reliability to constitute substantial evidence. We disagree. As the hearing officer found, the daughter's disclosures were graphic and specific, and they detailed events beyond the scope of knowledge of a typical 9-year-old child. In addition, such statements were made in material part consistent with those that the daughter separately had made to her mother. The plaintiff points to various factors that he claims called into question the reliability of the daughter's statements. He points out that he and the mother were going through a contentious divorce at the time of the disclosure, suggesting that the mother might have put the daughter up to making them. Folks, that's what every frauditor says. That's what every time they get caught, that's what they say. Oh, it was an accident, or, oh, I've been framed. That is the classic frauditor defense when they get accused. That's what they all say, though. And that's the problem. That's why it's not a defense, because they all say it. The hearing officer carefully considered each such factor. For example, she observed that the daughter's being embarrassed and upset with her mother for telling others about the disclosures goes against any argument that the mother was responsible for the disclosures. The hearing officer carefully weighed all the evidence, including the evidence that fairly detracts from the supporting evidence's weight. Okay, so this is Eric Neal's attorney representing the individual on behalf of this individual suing the DCF, representing someone who molested their daughter. Suing DCF because DCF protected a child. Think about that. Think about that for a second. This attorney is representing someone who is suing DCF for protecting a child from sexual abuse. Think about that. How disturbing is that? And this is Eric Neal's lawyer. Yeah, victimized and play the victim. I then further, okay, let's. And wait till you see what I found, though. Wait till you see what I found. I then further researched Neal's lawyer, Eric Hagen, and what I discovered was shocking. I discovered that Mr. Hagen worked for a law firm expressly committed to representing sex offenders specifically. And this is the website, folks, and this is Eric Hagen, second from left in the image. Do you see my mouse cursor? If you can't see my mouse cursor, Eric Hagen is second from left in the image. And this is his website, Liberty Law Group. Lincoln sex offenses lawyer. Relentless defense when everything is at stake. Sex crime accusations destroy reputations before any trial begins. An allegation alone triggers no contact orders, emergency custody modifications, professional license suspensions, and employment termination, as they should. Liberty Law Group defends sex crime charges in Lancaster County and federal court. Our Lincoln criminal defense attorneys handle sexual assault allegations, internet sex crimes, child pornography charges, indecent exposure cases, and sex offender registration violations with aggressive advocacy. Aggressive advocacy focused on protecting your constitutional rights, not the rights of the victim who was sexually abused, but the abuser's constitutional rights. Aggressive advocacy. This is the attorney Neal went to and sought out and hired. This is the attorney he went and hired. If all of what we already discussed wasn't enough, our Lincoln sex offenses lawyer understands that these cases demand immediate, discreet representation from attorneys who never judge their clients and fight relentlessly to protect a sex offender's and sexual abuser's freedom and reputation. For a confidential consultation, reach out to us. Why choose Liberty Law Group for sex crimes defense in Lincoln? Liberty Law Group handles criminal defense cases across Nebraska. Sex crime allegations require attorneys who understand forensic interview protocols and the complex registration requirements that follow many convictions. We defend these cases with the same relentless advocacy we bring to all criminal matters. Early defense attorney involvement protects your rights, Neal, during these critical investigative phases. Once charges arise, we scrutinize every element to identify weaknesses that create defense opportunities. We successfully defended clients through aggressive motion practice, effective cross-examination, and strategic case presentation that creates reasonable doubt for sexual abusers. Think about that. Yvonne, that is great. That is a great observation. We fight to avoid convictions requiring registration through aggressive trial defense, strategic plea negotiations that reduce charges to non-registerable offenses. So he fights to get sex offenders off the hook. And effective sentencing advocacy. When registration becomes unavoidable, we work to minimize registration duration and challenge improper classification decisions. I mean, we can go on and on. If you want to read his website, here it is. Okay, well, I don't need to go through. I think we get the point at this point. Okay. I then filed a motion after researching Neal's lawyer and discovering who he was and what kind of people he represents. I filed a motion for cost of service of process because since Neal failed to waive service of process as required by federal law, he must now reimburse me the $100 I paid to the Essex County Sheriff's Office to have Neal served. I also provided Neal's lawyer with all of Neal's YouTube community page posts and YouTube videos I used against Neal and intend to use against Neal in the future. Okay, and here's that motion. Remember, he failed to waive service of process as required by federal law. And if he fails to waive, he has to reimburse me the costs that I paid to have him served. And this is my motion for those costs. Plaintiff hereby moves this court to enter an order commanding defendant Neal to pay plaintiff the amount of $100 to indemnify plaintiff for plaintiff's cost of service of process. Plaintiff states as follows in support. On March 13, 2026, plaintiff filed this lawsuit. On April 25th, 2026, defendant Eric Neal posted to his YouTube community page, quote, "Dude, I'm begging you, please have me served. Tell the process server to email me and name the time and place. I will accept the paperwork with a smile." Defendant further stated in his post, again, or end quote, defendant further stated in his post, quote, "Again, have your process server reach out to me," end quote. We reviewed his posts. We discussed his posts, openly admitting that he would receive and accept service of process. Okay. On April 26th, I mailed defendant 2 copies of the waiver form, a copy of the complaint, a cover letter requesting waiver of service, and a self-addressed stamped envelope. I then emailed defendant a waiver of service. On April 26, 2026, defendant posted more to his YouTube community page. And we already reviewed and discussed these posts in this video earlier, folks. And now what I'm doing is I'm using his posts against him. I'm showing the judge here, not only did he fail to waive service of process, he openly admitted to failing to waive service of process and openly admitted to refusing to comply with federal rules requiring him to waive service of process. And I'm just showing the judge all of his posts that we already here's what the law says. Federal Rule of Civil Procedure Rule 4 states an individual has a duty to avoid unnecessary expenses of serving the summons or lawsuit. The plaintiff may notify such a defendant that a lawsuit has been commenced and request that the defendant waive service of a summons or waive service of a lawsuit. The notice and request, and then it provides how the circumstances, how it must be served, what it must state, yada yada. Federal Rule of Civil Procedure Rule 4 states if a defendant located within the United States fails without good cause to sign and return a waiver of service of the lawsuit requested by a plaintiff located within the United States, the court must impose on the defendant the expenses later incurred in making service. So the law requires that the judge impose on Eric Neal the expense that I incurred in having the Essex County Sheriff's Office serve Neal. And then I make all the arguments in this motion that I already made in this video. Plaintiff moves this court to find that Neal failed to waive service without good cause and enter an order commanding defendant to indemnify plaintiff in the amount of $100. Okay. Now, after I filed that motion, after I filed this motion, what happened? Eric Neal deleted his channel. Neal then deleted all of his YouTube content after I exposed him. After I used all of his content against him and it was too late, he then deleted his channel. And there we have it, folks. There we have it. If that didn't teach, if that's not proof that I taught him a lesson, I don't know what is. He's scared and he should be. So now, Neal can everybody see this? Can everyone see this? Neal is now renting his front yard in the suburbs as a campground site. Neal is now renting his front yard as a campground site on hipcamp.com. Okay, and this is his profile. Look at this. This is Eric Neal right here. Hosted by Eric, Middleton, Massachusetts, which is where his house is, and he's calling his front yard that he's renting as a campsite the Suburban Nook. Suburban and camping are mutually exclusive concepts, Neal. You can't be in the suburbs if you're camping, and you can't be camping if you're in the suburbs, Neal. And here he has his pictures. Okay. And look at this beautiful view of the neighbor's house, a campground site. The camping sites, most prominent view is the neighbor's house. That just robs camping of all of its enjoyability. I mean, that's what makes it not camping, is that you can see the neighbor's house, folks. Okay. Now let's look what he says. Welcome to the Suburban Nook, a quiet wooded campsite tucked away on a residential property in Middleton, Massachusetts. You're getting, folks, this is so funny to me. You're getting a genuine New England woodland setting with mature pines, natural stone walls, and a real campfire, but in a suburban neighborhood. That's the catch. That's the catch. You're getting a real camping experience, except that it's not camping. For people, what the fuck is this? Who tries to sell their front yard as a camping experience? Who tries to sell the suburbs as a camping experience? Okay, neighbors exist. Occasional background noise is part of suburban life. And the house is off limits, but the campsite itself is your own private space. Occasional background noise. Is that what you make when you're camping, folks? Or do you make more noise than that? He's saying occasional background noise is part of the suburban life. Yeah, but you're selling this as camping life, not suburban life. So there should be more than occasional background noise tolerated. The site comfortably accommodates up to 4 guests and 2 vehicles. A lighted path. What's lighted path? Is that you holding your flashlight walking in front of them, Neal? A lighted path leads from the parking area to the campsite, where you'll find a stone fireplace, or as we saw, basically a stack of rocks, a pile of rocks, a pile of rubble. It's been arranged. Campfire chairs, a table, complimentary firewood. Folks, this is what you get. This is what you get when you book a weekend at Camp Neal. All right. Camp Neal offers parking area, stone fireplace, campfire chairs. You get chairs, folks, and you get a table. You get complimentary firewood, and you get A couple bottles of water? Wow, that's generous. You get a couple bottles of water to get you started. A full-size cooler is available for your use. Fire suppression water is provided on site. Just ask if you need more. Neil, I have to ask, is the fire suppression water the 2 bottles of water you gave me to drink? Is that what I'm supposed to use? Now, folks, listen to this. Listen to this. This is the title of this live stream right here. A designated waste disposal barrel is provided on site. Please be sure to properly secure your waste before dropping it in the barrel. A designated waste disposal barrel. So he wants you to use the bathroom in his yard in a barrel. And then he wants you to have all the pleasure of properly securing your own waste. What does that mean? Catching it? What are we supposed to do? Catch our waste before dropping it in the barrel. And I don't know if he must have deleted this, but before it stated he had leaves he had dried leaves as compost. Yeah, so he deleted that part, folks. It said that dried leaves were available next to the bucket for composting. And he deleted that. But think about this. You have all the pleasure of catching yourself in indecent exposure charge because compliments of Camp Neal, compliments of the Suburban Nook, you have all the pleasure of now getting charged with indecent exposure because you're now using the bathroom in public in a bucket in Neal's yard, visibly in front of neighbors. And he's selling that as an experience, people. And I can't believe he deleted his he deleted the leaves that he deleted where he stated that he provides leaves, dried leaves, next to the waste disposal, next to the he called it something else. Oh, the compost. He called it a compost bucket. So he's calling you securing your own waste and tossing it into a barrel. He's calling that composting. He's calling that and you using leaves composting. And he deleted that. I don't know why he did that. I mean, that actually made it look better. I mean, now he just left it. Now you're just using the bathroom in a barrel. I mean, what are we supposed to do now, Neal? You had a solution before. Now there isn't one. I mean, and then these are the nearby attractions. A trail, a pond, another trail, and an ice cream parlor. There's your vacation. Yvonne, I have pictures of the inside of Eric's house. I haven't showed them to anybody yet. I don't think I showed them on my channel yet. I may have, but I don't. But I have pictures of the inside of his house, and wait until you see it. Wait until you see it. So that was a pretty long live stream, folks. So Eric is essentially advertising free indecent exposure charges to all welcome visitors, to all lucky welcome campers. Compliments of Camp Neal. Oh yeah, $40 a night. It's only $40 a night. Look, one night, 40. Oh, look, here it is. Toilet. Look what he says. Toilet. He literally, what to expect? He literally claims that a toilet is available. He literally advertised a toilet on his website. That is false advertising. That is completely and entirely false. That is not a toilet. Look at this. He listed that as an amenity. He listed you securing your own waste and tossing it into a 5-gallon plastic bucket as an available toilet. And now he's calling it a composting toilet. Man, I don't think that I want any water from you at this point, Neal. I wouldn't want to ingest anything from that you offer me, food or water. Let's go through some of these pictures. Okay. There's his pile of rubble. This is his trail. This is what he's calling a path. From his house to his front yard. And look at this camping table. A large tarp is provided for the ground beneath your tent. No charge. Oh, thanks, Neal. You're not charging us for securing our own waste in your compost bucket, toilet bucket either, are you? And there's your bug light lighted path. All right, that's it for this live stream, folks. This is too funny. I don't even know how long this live stream was, but this is definitely the longest one I've ever made. Yes, church. That you know, I don't think he understands what I have not looked into the ordinances or the laws regulating campsites or regulating his activity or what he's doing. But I have not. But I'm almost fairly certain if I were, I would find violations. I'm almost positive. I mean, I agree with you that he's probably committing some kind of code violation. I mean, you can't, because there places are zoned as certain kinds of properties for a reason, and you can't just rezone one property or turn a property into another without, there's a process you go through for that, and so if it's even allowed, a lot of times it's not even allowed. There is no problem. You just can't do it. Areas are zoned for specific reasons. All right, that's all for this live stream, folks. Thank you all for being here. Thank you for your attention to this matter. Good night, goodbye, and I love you.